Good morning, friends. I hope you know that the Marcus incident, which has spread the so-called corona or COVID-19 pandemic because of the congregation of so many foreign nationals, or we can call them as Tablighi Jamaat, all these people near in Delhi Masjid. So this has caused a sensational news at the particular point of time, and they were actually literally detained, and number of cases were booked against them under National Disaster Management Act, or for violation of COVID-19 protocol. That means they should maintain the social distance, they should not congregate, all these. Of course, they are all minor offenses, right? So very recently, about 60 Thai nationals, Thailand people, of course Muslims, so they have, that means gone for plea bargaining before the court, before the magistrate. So they have gone for plea bargaining, and they were made to make or they were made to deposit a fine of rupees 6,000 each to the PM Cares Fund. They paid it, and now they walked free. That means no case against them. Second, the Nepalese, 14 Nepalese, they have been asked to pay a fine of rupees 4,000 per head to the PM Cares Fund, and they were also let off. How? This is with the use of plea bargaining. Now let's know what is plea bargaining. Of course, it came into existence with the Criminal Law Amendment Act 2 of 2006 with effect from 5/7/2006. This concept of plea bargaining came into effect in 2006, and it is mentioned in chapter 21A from, of course, amendment is there, section 265A to 65I. Now let's know what is plea bargaining. Plea bargaining means, it is plea. Plea means already know. Bargaining, requesting or negotiating. Suppose if any person is likely to be convicted of an offense, then he can negotiate or he can plead for the bargaining. You may be knowing bargaining. Bargaining means normally when you go to the market, or normally our people, we go to the vegetable market and we bargain. తోటకూర కట్ట 10 రూపాయలు అంటే 8 రూపాయలకి ఇవ్వరాదా, కేజీ వంకాయలు 40 రూపాయలు అంటే 20 రూపాయలకి ఇవ్వరాదా. This is what is called bargaining, right? So they also bargaining for the conviction. Of course, here they admit the offense. There is no point. They admit the offense, and if they are sure that they will be convicted, then only they will go for the so-called plea bargaining. Now let's know what is plea bargaining. So section 265, what I said is correct. It is incorporated in CRPC. So the person charged with a criminal offense negotiates for a lesser term of punishment, right? It is quite common in the USA. When once the charge sheet is laid against him, normally the court will say, the jury will say, the jury will ask the attorney. So you hold some talks with the accused person whether he is going for a plea bargaining or not. So why? Because when once the plea bargaining is there, the result of the case will be conviction, and the percentage of conviction rate of conviction will increase. At the same time, this man did not suffer the imprisonment to the maximum sentence. Suppose if he committed theft, the maximum punishment is 3 years. Suppose if he agrees, then the punishment may be lessened to maybe 1 year or maybe 6 months. That means half or 1/4 of the same. That depends on his request or his pleading, right? The second is to avoid the protracted and complicated trials. And third, the advantage I will tell you later. So definitely you may be knowing the case of 2020 will come for trial in 2024. So he has to be in an anxiety mood till 2024. We can't know. And once the case go to the court, we don't know the result. So that problem. So the man can be relieved happily, and therefore the pre-trial negotiations definitely regarding the quantum of sentence, definitely they are useful. But this is not in practice in the country like India. Normally we try to avoid the sentence. Normally we try to say no, we have not committed an offense. That's why it's not successful in India. Of course, very recently, why I am doing this video is very recently the Tabligis, since they have accepted, they have pleaded for the so-called plea bargaining. They have asked for the concession. They were just given the fine and asked to go away. Happily they could go away. Otherwise they have to languish in the jail, or they have to stay in India for so many years till the trial is completed. It may take definitely 2 to 3 years. Because recently, that means about 3 years back, we have seen a Sri Lankan person being caught near Itamukkala, and a case under for the Foreigners Act was registered against him. So his son was staying in Canada. So by the time the trial was completed, it was nearly 3 years. And for getting the passport from the passport office, after getting clearance from the court, it has taken him 8 months more, and ultimately he went back to Sri Lanka. So such a time, see, 4 years, almost 4 years he has wasted. So the time is definitely to their advantage. So the Law Commission, in its 142nd report, they have mooted the idea of concessional treatment, that is lessening the period of punishment, lessening the quantum of sentence. Of course, they have given certain conditions also. They were very careful. So because suppose if a murder case criminal, if he says, yes, I want lesser punishment, it is not allowed. Now I will come to the topic that also. Right? So normally I can say that the plea bargaining will be allowed in most of the major offences, and they will take all care. They are limited. So here the limitations are: number one, plea bargaining will not be accepted. Number one, in cases where the punishment will be death, in cases where the punishment will be life imprisonment, or in cases where the punishment exceeds more than 7 years. Another point, in case the offence is against a woman, in case the offence is against a child below 14 years, in case the offence involves socio-economic conditions. So these are all the limitations. So in these cases, there is no question of plea bargaining. Other cases only there will be free bargaining. So what is the procedure? The applicant or the person who wanted to negotiate or to lessen the period of conviction, he has to file an affidavit and also a sworn statement before the court. That means to say that it is voluntary. He wanted to get the sentence lessened. Right? He has to file an affidavit stating that his voluntary preference, and that he has understood the nature and the maximum punishment as per law. Then the magistrate will call the so-called person or accused and hold in camera proceedings to satisfy himself whether he is giving the statement or whether he is going for the plea bargaining voluntarily or not. Then he will call the other party, first of all he will call the public prosecutor, then he will call the police officer and also the other party and hold talks with them. If they come up with a mutually understanding proposal, then he will deliver the so-called punishment time, that is quantum of sentence. Of course, then also people will bargain. Ultimately, they will ask him to impose some fine. It may be allowed at times. Ultimately, the judgment will be given. When the judgment, normally, please remember, here the judgment is conviction, and there is no appeal also. So very simple process, but in India, normally the advantage I want to tell lastly, it is relating to speedy trial, is it not? So second is anxiety of the parties on the result. No doubt one. Once the case is booked against a person, normally he will not have free time. He will not have free sleep also. Always he will be thinking of the case. The result will may come after 4 to 5 years. So that anxiety neurosis will be there. So when once the case is decided, he is totally relaxed and he can be happy. And for the police or for the prosecution, there will be a rise in the conviction rate. In Illinois, already we are commenting that the conviction rate is very less in India. With this, since it is a case of conviction, definitely the conviction rate also will be more. But here, please remember, there are certain judicial officers also. I think they have got some reservations. They say already the court has got umpteen powers. The court will already, I told you, justice, equity and good conscience. So by using the principles of natural justice or by using the so-called dharma, normally they depend. So they will decide on the ignorance part, on the poverty part of the accuser, and they may lessen the sentence also. Already there is a provision for lessening the sentence. For that matter, of course, there is a provision in CRPC. If anybody pleads guilty, then he can be punished. The quantum of sentence, normally there may be maximum, but it depends on the definitely purview of the judge, and it is in the discretion of the judge. For example, if a murder is committed, there is no guarantee that even though he admits the offense, the judge should give death sentence. He may be given only 2-year sentence also. So when that power is with us, why this plea bargaining? Some magistrates or some judges are also saying, but anyway, even though they, of course, they are particular about the poverty or innocence, all these things, but it is a good process and a developing change, a trend in the legal aspects, particularly in the other countries. And the best example, very recently, the Thai Walas and the nation Nepalese, both of them have simply gone away. They have walked free from the court with happiness, because after all, they are all minor offences. Suppose if the trial has to go, definitely I am sure it may take not less than 2 years. So how can they stay in this country for 2 years? Definitely, no doubt, whether they committed the offense, whether they violated the COVID norms, all those things, it is a different part. But keeping a person in India for so many days, it may lead to so many complications, and plea bargaining has actually come as a gift to them, and they have utilized it. So you have to encourage our people also to go for plea bargaining. Of course, it is very, very less in India. So this is all regarding the plea bargaining. Please remember, while you study the CRPC chapter 21A, I believe, that is section 265A to 265I, deals with the so-called plea bargaining. Friends, plea bargaining means, I am sure you know the result, the conviction. So you wanted the conviction period to be lessened, to be degraded, so that you can run the sentence, you can actually be in the jail for a small time and come back. That is the intention. So it is not lok adalat. There is a difference between lok adalat and plea bargaining, and lok adalat totally compromise and acquittal. Here it is conviction. Please remember the difference also. Anyway, thank you very much.